Hi, I'm Rav Pratap, and this is a tax lawyer's perspective on the Safari Retreats case. I promise it's a treat of a discussion. It's a treat for me. Whether it's a treat for you too, you can decide once you've heard me discuss the case. One caveat for this discussion is that you should be aware of the concept of input tax credit, that is ITC. If not, I suggest that before listening to this discussion, you familiarize yourself with the concept of ITC, even if at an elemental level. It will be helpful as my discussion is based on the assumption that the viewers or listeners are aware of the concept of ITC. This discussion on Safari Retreats case is divided into 6 sections. I begin by telling you the facts of the case. I follow it by analyzing the Orissa High Court's judgment and then the Supreme Court's judgment, which is the core of the discussion. Thereafter, I briefly discuss the functionality test mentioned by the Supreme Court in its judgment. I examine what it means, its relevance to GST, and I comment on whether the functionality test has any future under the GST jurisprudence. I then wrap up the discussion by telling you about the Retrospective Amendment that followed the Supreme Court's decision and conclude by asking you whether we have learnt anything from the developments relating to Safari Retreats case. Well, some of you might already know the answer to this question, but I think it is still worth asking, if only for the purpose of exploring some additional answers. Let us begin then. So, what were the facts of this case? Not too complicated. In short, the facts were that the petitioner, that is Safari Retreats Pvt Ltd, accumulated ITC but was unable to utilize it against the output taxes. The Revenue Department blocked the ITC of the petitioner, and the petitioner was, let's say, unhappy. Petitioner was primarily in the business of construction of shopping malls and thereafter letting out or renting various units in the shopping mall to numerous tenants. During construction, petitioner purchased a variety of materials such as wood, cement, amongst other construction materials, as well as availed the services of architects and other professionals. As a purchaser of these goods and the recipient of these services from professionals, the petitioner paid GST on the above-mentioned input goods and input services. This is the amount that petitioners claim they paid as GST on the various inputs and input services: 34 crores 40 lakhs 18,028 rupees. Having completed the construction of a shopping mall, the petitioner decided to rent various units of the shopping mall to different persons. And petitioners collected rent plus GST from its tenants, since renting commercial units is taxable under GST. Petitioner's claim was that it should be allowed to claim ITC for the GST it paid on its input goods and input services and adjust it against the GST collected on rent. Petitioner's argument was that both its transactions formed an unbroken chain. It had paid GST on its inputs, that is the construction material and related services, and then it collected GST on its output, that is the renting of units in the shopping mall. Since the chain between its input and output was not broken, the petitioner insisted that it should be allowed to claim ITC. Petitioner argued that allowing its ITC claim would prevent cascading effect of taxes and also not cause any loss to the Revenue Department. The Revenue Department's response to petitioner's ITC claim was no ITC allowed. The Revenue Department relied on Section 17(5)(d) of the CGST Act, and more about this provision in a couple of minutes. Let me use some hypothetical numbers to explain the petitioner's claim and thus the dispute. Let's say petitioner's claim was that they paid 24 crores as GST on their inputs and they collected 28 crores as GST from their tenants. Petitioners were saying, allow us to claim ITC for the taxes that we've paid on our inputs. It will reduce our net output tax liability. In this hypothetical scenario, the petitioner's net output tax liability would have reduced to 4 crores if they were allowed to claim ITC. But the Revenue Department refused. This is how the petitioners viewed their tax liability. Petitioners said, look, we've already paid the GST on our inputs. Allow us to claim ITC against the GST that we've collected on our rent, and the net GST amount should be a final tax liability. Petitioners were of the view that there will be no loss to the Revenue Department as petitioners have already paid GST on inputs, and petitioners also claim that it is important to allow the ITC claim as it will respect one of the core objectives of GST, that is to prevent cascading effect of taxes. And this is how the Revenue Department viewed the petitioner's tax liability. It said, you pay us all the GST that you've collected on your end, but you are not allowed to claim any ITC for the GST that you've paid on your inputs. So the final GST liability of the petitioners will not include any ITC claims. Needless to say that the petitioner's output tax liability would have significantly reduced if they were allowed to claim ITC. And allowing petitioners to claim ITC would have respected a core objective of GST, that is to prevent cascading effect of taxes. But it is also worth mentioning that just because you paid GST on your inputs doesn't mean you will in all circumstances be allowed to claim it as ITC. There are various situations contemplated in the statute where ITC is blocked. Finally, this judgment doesn't reveal the exact number in terms of how much ITC the petitioners were claiming. We only know how much GST that they paid on their inputs. But a calculated guess would suggest that the amount being claimed by ITC was a significant amount given the nature of their business and that they were willing to fight this case up to the Supreme Court. So why was the Revenue Department refusing the petitioner's claim? The Revenue Department was relying on Section 17(5)(d) of the CGST Act. Section 17(5)(d) stated that ITC shall not be available in respect of goods or services or both received by a taxable person for construction of an immovable property, other than plant or machinery, on his own account, including when such goods or services or both are used in the course or furtherance of business. Now, as per the Revenue Department, the petitioner fulfilled all the ingredients listed in the provision. It constructed an immovable property, the immovable property was constructed on own account of the petitioner, and the goods or services were used in the course or furtherance of the petitioner's business. Thus, the Revenue Department claimed that ITC is not available to the petitioner as per Section 17(5)(d). Now, why have I highlighted this phrase other than plant or machinery in brackets? Mostly because I felt like it, and also because it is relevant to the discussion that will follow when I examine the Supreme Court's judgment. The Revenue Department cited Section 17(5)(d) to deny or block the petitioner's ITC, and the petitioner said, "I will see you in court." And the first court that the petitioner approached was the Orissa High Court. On that cue, let's move to Section 2 of this discussion. What did the Orissa High Court say on this dispute? In short, the Orissa High Court said to the petitioner, "You want ITC, you take ITC. Simple." But to be a bit serious, it wasn't this simple. There was more to the judgment. The Orissa High Court's judgment reproduces arguments of the petitioners in significant detail. It, of course, also mentions arguments of the Revenue Department, but in a cryptic fashion. Or maybe the Revenue Department did argue in a limited fashion, I am unaware. Finally, the High Court's reasoning and conclusion comprises a minuscule part of the judgment, but more importantly, the High Court's reasoning is not entirely convincing. So let's look at the High Court's conclusion first. The High Court observed that GST laws have been enacted to ensure there is uniformity in collection of tax on intrastate supply of goods and services and to prevent multi-taxation. And when the High Court here is talking of multi-taxation, it is referring to multiple indirect taxes at the state and union level that were in vogue before GST, and the presence of those multiple taxes that led to cascading effect of taxes. The High Court added that GST Department's narrow construction of Section 17(5)(d) is preventing and frustrating the very objective of the Act. And here again, when the High Court refers to the objective of the Act, it refers to the prevention of cascading effect of taxes. Overall, the High Court was convinced that the Revenue Department's disallowance of the petitioner's ITC claim will lead to a cascading effect of taxes and defeat a core objective of GST. And this is what the High Court's exact conclusion was. While considering the provisions of Section 17(5)(d), the narrow construction of interpretation put forward by the Department is frustrating the very objective of the Act, inasmuch as the petitioner in that case has to pay a huge amount without any basis. Now, I'm not sure that the Revenue Department's insistence on denial of ITC was without any basis. The Revenue Department's denial of ITC was based on its reading and interpretation of the provision in question. And for the High Court to dismiss it by simply terming it as without any basis wasn't a convincing engagement with the Revenue Department's argument. Irrespective, one thing was clear, that the High Court certainly and clearly did not agree with the Revenue Department's stance and interpretation. This is how I can present a snippet of the interpretive approach of the Revenue Department and the High Court in this case. While the Orissa High Court termed the Revenue Department's interpretation as narrow, it was, in my opinion, more accurate to term it as strict interpretation of the provision. The Orissa High Court, on the other hand, adopted the purposive interpretive approach, where instead of reading the provision as is, the courts refer to the object and purpose of the statute to interpret a provision. While purposive interpretation is not alien to tax law, it is advisable to follow it only in cases of ambiguity in the provision. And the High Court didn't satisfactorily discharge the burden of establishing that there was ambiguity in the provision. The High Court concluded that in our considered opinion, Section 17(5)(d) should be read down, and the narrow reading imposed on the provision by the Revenue Department should not be accepted. Strangely, the High Court's judgment doesn't contain any detailed examination of the provision or whether the petitioner could claim the plant machinery exception, which I mentioned earlier. Maybe the High Court was so convinced of the need to read down the provision, it thought it was unnecessary to refer to the exception of plant machinery. Though to give benefit of doubt to the High Court, it is possible that the petitioner did not try to claim the exception of plant machinery before the High Court. This question of invoking the plant machinery exception aside, another point worth underlining again is that in High Court's conclusion, we see an unqualified adherence to the purposive interpretation instead of the more appropriate strict interpretation of a tax statute. Lastly, the High Court's core reason was that the objective of ITC was to give benefit to the assessee, and it cited the Eicher Motors case to support its observation. A quick word on the Eicher Motors case. The Eicher Motors case involved adjudication on the change in Central Excise Rules 1944, more specifically Rule 57F4A. The change specified lapsing of the non-utilized modified value-added tax credits or MODVAT credits of assessees as on 16th March 1995. When this issue reached the Supreme Court looked at the issue from the lens of the rights of the assessees. For those wondering, MODVAT credits can conceptually be understood to be the rough equivalent, if not the exact replica of ITC. MODVAT credits were available under the excise regime and ITC is available under GST. Now, what was the specific change made to the taxpayer's right to claim MODVAT credits? Rule 57F4A, after amendment, stated that credit shall lapse for inputs that have been used in manufacture, even if the final product was cleared before 16th March 1995. Supreme Court, however, said that an assessee became entitled to the MODVAT credit once the input was purchased in the factory on the basis of an existing scheme. And the right to claim the MODVAT credit became absolute once the input was used in manufacture of the final product. If the assessee purchased inputs, paid taxes on it, and used it for manufacture, the assessee is entitled to claim MODVAT credits even if the assessee may not have claimed or utilized a tax credit on the cutoff date of 16th March 1995. Changing the rule afterwards and saying that the unclaimed tax credit shall lapse was prejudicial to the assessee's rights as per the Supreme Court. Now, the Eicher Motors decision of the Supreme Court was certainly on input tax credits, more specifically MODVAT tax credits, but the context was where the right to claim these tax credit can be altered once the taxpayer has paid the taxes on inputs. Safari Retreats case, on the other hand, was simply about interpretation of a statutory provision and whether a taxpayer could claim ITC. There was no amendment or other change that altered a previously existing right. The Orissa High Court nonetheless used the Eicher Motors case to categorize ITC as a benefit provided to taxpayers and used it to support its reading down of the provision, that is Section 17(5)(d) of the CGST Act. Eventually, though, Eicher Motors case proved to be completely irrelevant to the Supreme Court's decision. This brings me to the core part of this discussion, that is Section 3. What did the Supreme Court say on this dispute? Quite a few things actually, and most of its observations were in favor of the petitioner. The cornerstone of the Supreme Court's judgment was its endorsement and, more importantly, its application of the doctrine of strict interpretation. It's a delight when the courts not only endorse a doctrine but apply it appropriately and don't opt for easy cop-outs. And this Supreme Court judgment is an example of applying the doctrine of strict interpretation appropriately. Let's discuss the Supreme Court's approach in more detail. But before the details, a customary summary. A one-sentence summary of the Supreme Court's judgment is that "and" cannot be interpreted to mean "or," they are two different words. By stating the above, the Supreme Court applied the doctrine of strict interpretation. Supreme Court added that in the context of this case, interpreting "and" to mean "or" would amount to violence. I think the Supreme Court was referring to interpretive violence, but I'm not sure. Regardless, may the peace lords keep showering us with their blessings, and hopefully none of us ever witness violence, interpretive or otherwise. The judgment also contained a plea for humanity. In the initial part of the judgment, the Supreme Court made a plea to the various parties of the case and observed, "There are a large number of decisions relied upon, whether relevant or irrelevant. Brevity is the hallmark of good advocacy. It would be ideal if parties on one side file joint written submissions. The judges and lawyers are humans." And then some people say tax law is dry and contains no human element. Anyhow, let me get serious. These are the key elements of the Supreme Court's decision: the doctrine of strict interpretation, the functionality test, and its observation on constitutionality of tax law provisions. I will discuss the first two elements in detail and only make a passing reference to the third, since the case was effectively decided on the first two parameters. I will begin by discussing the first element of strict interpretation. But before I discuss the doctrine of strict interpretation, let me introduce you to the provision that was the focus of interpretation, that is Section 17 of the CGST Act. Now, Section 17 enumerates various situations where ITC for a taxpayer is blocked. But it also provides caveats and exceptions where ITC may be available. This fine dance between blocking ITC and permitting it in certain situations often requires an interpretive exercise. And the Safari Retreats case is an example of this dance. But because this is tax law, there is no music in the background. All you will hear is my voice for the next few minutes. Ordinarily, I would apologize for my voice, but you are the one who's watching videos on tax law. You should have a hard look at what has gone wrong in your life. Alright, let's go to the relevant part of Section 17. Section 17 subsection 5 contains various clauses. The principal clause states that, notwithstanding anything contained in subsection 1 of Section 16 and subsection 1 of Section 18, input tax credit shall not be available in respect of the following, namely, and Clause C of Section 17(5) names works contracts and blocks ITC for works contract services when applied for construction of an immovable property other than plant and machinery, except where it is an input service for further supply or works contract service. As you can see, ITC is blocked for works contracts, but there are two exceptions: when plant and machinery is involved, and works contract services are inputs for other works contract services. This is what I was referring to. Whether a particular fact situation is covered by the rule or the exception is frequently an interpretive exercise. Section 17(5)(d) in turn blocks ITC for goods or services or both received by a taxable person for construction of an immovable property other than plant or machinery on his own account, including when such goods or services or both are used in the course of furtherance of business. In both clauses, there is one similar exception, but not the same exception. If you don't want to hear me going on and on, then this is the core dispute of the case: whether both the expressions plant and machinery, as well as plant or machinery, mean the same. Or does the use of and use of or respectively change the meaning and scope of the exceptions? I've already told you what the Supreme Court said on this point. Now, if you haven't stopped watching, let's elaborate on the dispute. Explanation to Section 17 stated that, for the purposes of this chapter and Chapter 6, the expression plant and machinery means apparatus, equipment, and machinery fixed to earth by foundation or structural support, that are used for making outward supply of goods or services or both and includes such foundation and structural supports, but excludes land building or any other civil structures, telecommunication towers, and pipelines laid outside the factory premises. Now, what is the implication of this explanation in the context of this case? Now, Section 17.5c uses the expression plant and machinery, while Section 17.5d uses the expression plant or machinery. Explanation to Section 17 defines the expression plant and machinery. So the question before the Supreme Court was whether the definition of plant and machinery in the explanation to Section 17 also applies to the expression plant or machinery used in Section 17.5d. Now, you want further clarity? Here is my attempt at providing further clarity. These are both the relevant clauses of Section 17 and the explanation of Section 17 in one single place. The explanation defines the expression plant and machinery. So this is clearly applicable to Clause C, which also uses the same expression plant and machinery. But can this definition of plant and machinery also be applied to Clause D, which uses the expression plant or machinery? That is a million-dollar question. Well, not literally a million-dollar question, but I'm sure you get the point. Supreme Court, before answering the question of the applicability of the explanation, analyzed both the above-mentioned clauses of Section 17.5. But I will only examine Section 17.5d in detail as it is more relevant to the discussion. Supreme Court said that Section 17.5d blocks ITC on goods or services or both received by a taxable person to construct an immovable property. And there are two exceptions in the provision, that is, when ITC is allowed under this clause. First, if the immovable property is plant or machinery. Second, if the goods or services or both are received by a taxable person for construction of an immovable property not on their own account. Now, I will discuss in detail the meaning of plant or machinery, but first let me tell you what the Supreme Court said about the second condition, that is, about construction on one's own account. Now, as per the Supreme Court, construction is said to be on taxable person's own account when it is made for his personal use and not for providing a service, or it is to be used by the person constructing as a setting in which the business is carried out. However, construction cannot be said to be on a taxable person's own account if it is intended to be sold on lease or license. There are two things that need to be said about the Supreme Court's above observations. First, that the interpretation of the phrase on own account seems to come out of nowhere, in the sense that it is neither supported by reference to any arguments made by parties, judicial precedents, nor any provision of any other statute. Second, the latter part clarifies that if the petitioner is constructing a shopping mall for the purpose of renting out or leasing its various units, it cannot said to be construction undertaken on own account. Thus, if it is not on one's own account, the petitioner can claim the benefit of the exception, take ITC, as long as the petitioner can prove that the building in question, in this case the shopping mall, is covered by the expression plant or machinery. I will expand on this further in a few minutes, but suffice to say here that whether the phrase on own account actually means what the Supreme Court said will be known in future and will be tested in various cases. Now, coming back to the relevant provisions of Section 17 and the core question, what is the meaning of the phrase plant or machinery? Is it the same as the phrase plant and machinery? Let's go into the details of what both the parties to the case had to say about the issue. I will first elaborate on the arguments made by the petitioner and then proceed to what the Revenue Department argued. And of course, there are no prizes for guessing what the Revenue Department argued. Petitioner argued that Section 17.5d of the CGST Act can be interpreted in a manner that ITC is available to the petitioner for construction of immovable property when the immovable property is used for the purpose of further output supply. This implies that if the immovable property in question is used to make a further supply, in this case renting of units in the shopping mall, ITC should not be blocked as there is a seamless chain of purchasing inputs and making a supply of output via the immovable property. This argument of the petitioner was based on three prongs. Okay, the first prong. The petitioner said that Section 17(5)(d) exempts plant or machinery from blocked credits, which is distinct from the expression plant and machinery used in Section 17(5)(c). Thus, the explanation to Section 17, which defines plant and machinery, is not applicable to Clause D. Now, coming back to the relevant provisions of Section 17 again, the import of the explanation was that the plant and machinery did not include land, building, or any other civil structures. Thereby, ITC on all these three structures was blocked. Petitioner was claiming that the explanation was not applicable to Clause D. Thus, this gave the petitioner a window to argue that ITC on shopping mall, technically a building, was not blocked. This was, of course, subject to the petitioner proving that its shopping mall was plant or machinery. And for this purpose, the petitioner relied on the second prong of its argument. The second prong of the petitioner's argument was that malls, hotels, warehouses, etc. are plants and therefore exempted from the provision, meaning they are eligible for ITC. Relying on various judicial precedents, the petitioner argued that a building or a warehouse must be considered a plant within the meaning of Section 17(5)(d) if it serves as an essential tool of trade with which the business is carried on. However, if it merely serves as a setting in which the business is carried on, it will not qualify as a plant. Now, what is a tool of a trade and what is a setting in which the business is carried on? One of the examples from income tax law as to what constitutes a tool of trade is that for a lawyer or a legal professional, a book was once held to be a tool of trade. Lawyer's office could be said to be the setting. The idea is that anything that is needed to perform a trade, a thing that acts as a tool, must be considered as a plant, nothing else. Thus, vis-a-vis buildings, the concept is that if the building is needed to perform or conduct a trade, it is perceived to be a tool, and thus a plant for tax purposes. But if the building is merely a setting from which the business is carried out, it is not a tool and thus not a plant for tax purposes. Though I have to admit, it is easier to state the distinction in abstract and much tougher to apply it to specific set of facts of each case. The third prong of the petitioner's argument was their attempt to underline that the chain of tax was not broken. And for this purpose, they relied on comparing their position with taxpayers who constructed and sold an immovable property. Petitioner stated that under GST, if inputs are used to construct an immovable property, and the property is sold before the issuance of the completion certificate, ITC on the inputs is allowed since the chain is not broken. Petitioner was saying that they are in a similar situation and similar treatment should be given to renting or leasing out of immovable property since GST is collected on the rent. Now, the petitioner's third prong can be better understood if you look at para 5B of the Schedule 2 of the CGST Act. Under this provision, construction of a complex building, civil structure or part thereof intended for sale to a buyer is treated as supply of services, except where the entire consideration has been received after issuance of the completion certificate by the competent authority or after its first occupation, whichever is earlier. This provision presumes that a person who purchases an under-construction complex is a recipient of construction services. So the petitioner was saying that their output, that is renting of commercial units, should also be treated as a supply of service analogous to the construction service mentioned in this provision. While there may be merit in the petitioner's argument, it is worth remembering that cases are to be decided based on what the provision says and not what the provision could or should say. And petitioner's comparison with construction services was an attempt to get the case decided based on its view of what the law should be and not what the law is. Now, let's see what the Revenue Department argued. The Revenue Department argued that or should be interpreted to mean and. Why attribute different meanings to them? They should be treated and understood as the same. Taken to an absurd level, this argument would suggest that all words should mean the same thing. But let's not take an already suspicious argument to an absurd level. The Revenue Department argued that expressions plant or machinery, as well as the expression plant and machinery, must be treated as synonymous. Revenue Department's argument was that since Section 17(5)(c) and D both deal with construction of immovable property, it is important that the availability of ITC under both clauses is at par. Very briefly, a works contract, as mentioned in Section 17(5)(c), refers to contracts relating to immovable property, where the contract is for construction of immovable property as well as supply of the construction material. In other words, a very specific kind of contract relating to immovable property. In effect, the Revenue Department was saying that works contracts and construction of immovable property should be treated similarly under GST. The Revenue Department further added that the purpose of ITC is to remove cascading effect of taxes by removing the burden of the tax that is paid at the previous stage. Since no GST is payable on the sale of shopping malls, there is no need to grant ITC to the petitioner. Revenue Department pointed out that if a shopping mall is sold as an immovable property immediately after the issuance of the completion certificate, no GST is payable at the time of the sale, there will be no cascading effect of taxes, and thereby there is no need to grant ITC to the petitioner. Now, here you see how both sides are trying to interpret GST relating to immovable property to serve their ends. Petitioner was talking of the fact that GST is paid on immovable property when it is sold before issuance of completion certificate, which is correct, as purchase of an under construction immovable property is taxed on the premise that it is supply of construction services. Revenue, on the other hand, is emphasizing that no GST is paid on immovable property when it is sold after the issuance of completion certificate. That is also correct, because GST is not levied on the sale and purchase of immovable property if the completion certificate has already been issued. So what both sides are saying is the correct position of law. It is just that both sides are emphasizing on different aspects of the law that serves their purpose. The Revenue Department continued and argued that if the shopping mall is used to render renting service for 5 years and then it is sold after 5 years, no GST is payable on the sale. The Revenue Department explained that if it allows the petitioner's ITC claim, then during these 5 years, no GST will be payable at all, as all input taxes of the petitioner will be set off against their output taxes. They said the petitioner will exhaust their ITC during these 5 years on the rental income, and thereafter shopping mall will be sold without paying any tax, which would cause a substantial monetary loss. Now, this argument of the revenue best captures the reason why ITC on immovable property is blocked under Section 17(5)(d). While there have been no open deliberations as to the policies that drive various provisions of GST, but this argument of the Revenue Department reveals as to why taxpayers are generally not allowed to claim ITC on immovable property under Section 17(5)(d). Now let me try and explain to you the differing perspectives of the petitioner and the Revenue Department with the help of a couple of illustrations. The petitioner's claim was that the chain between its input and its output is not broken. That it is paying GST on the construction of shopping mall, it is collecting GST when it is renting various units in the shopping mall. There is no break in the chain. So where is the need to block ITC? It's a good question. The Revenue Department's claim, on the other hand, was that petitioner will use this ITC for a few years, and after the few years, then it will sell at the shopping mall. And on this sale, there is no GST that's payable because by that time, the completion certificate would have been issued. And because on sale of immovable property, no GST is collected, it will lead to loss of revenue. The Revenue Department's reason for blocking ITC is based on the premise that the shopping mall will be sold in the future. The accurate part of the Revenue Department's argument is that allowing claim of ITC will lead to loss of revenue if the sale happens. But this should not be understood to mean that sale of immovable property per se will lead to loss of revenue under GST laws. Anyhow, the Revenue Department's star argument was that even it is assumed that the two expressions plant or machinery as well as plant and machinery are distinct, Please keep in mind, this is a legislative error. The Revenue Department said that the legislature wanted to use the phrase plant and machinery in Clause D as well. It just mistakenly used the phrase plant or machinery. To repeat this argument, because I find it worth repeating, the Revenue Department argued that or must be read as and it attributed the use of the phrase plant or machinery to a legislative error, implying that the legislature wanted to say plant and machinery in both clauses, Clause C as well as Clause D of Section 17(5). Thus, the explanation to Section 17, which defined plant and machinery, must also be applied to the expression plant or machinery. The Supreme Court weighed the arguments of both sides and found the revenue side to be light as air. Let me take you through the details. Supreme Court set the framework of its ratio at the very outset by stating the foundational principles for interpretation of tax law. It said a taxation statute must be read as it is with no additions or subtractions. If language of a taxation statute is plain, the consequence of giving effect to it may lead to an absurd result, but is not a factor to be considered for interpretation. And finally, principle of strict interpretation must be applied for provisions of a taxation statute. It cannot be interpreted based on any assumption or presumption. The above rules highlighted that the limited role of judiciary in interpreting tax legislations. The words, sentences, etc. used in a tax statute must be interpreted without the judiciary adding or removing anything from the relevant tax provisions. Moving to the facts at the hand, Supreme Court then noted that the two clauses of Section 17(5) dealt with different transactions. Supreme Court observed that there is hardly a similarity between clauses C and D of Section 17(5), except for the fact that both are an exception to Section 16(1). Now, Section 16(1) lays down the conditions that a taxpayer needs to fulfill in order to claim ITC, while Section 17 prescribes the conditions when ITC is blocked. So that's the reason Section 17(5) operates as an exception to Section 16. Supreme Court added that the only other similarity in both the clauses is that they relate to construction of an immovable property, and the difference is that Clause C uses the expression plant and machinery, while Clause D uses the expression plant or machinery. Now, this wasn't just a difference, it was a crucial difference. Also, I need to mention here that the reason Supreme Court had to address the similarity or the difference in the two clauses was because the Revenue Department insisted that they must be interpreted similarly to prevent inconsistency in ITC claims for immovable property as well as works contracts. And the Supreme Court rejected the revenue's argument and refused to equate or with and. The Revenue Department had argued that the expression plant or machinery is used only in Section 17(5)(d), while the expression plant and machinery is used in 10 different places in the CGST Act. And thus, as per the Revenue Department, the use of the word or was a legislative error. The petitioner as a counter submitted that in the model GST law circulated by the GST Council, the expression plant and machinery was used in both clauses C and D. However, while enacting the legislation, the legislature has consciously chosen the expression plant or machinery, but only in Clause D. Now, I think this argument can go both ways. If the model legislation used and the final act used or, was it because of a legislative error or was it because of a deliberate legislative choice? I think either way it's a guess, since there are no detailed parliamentary debates at least, or other official documents to prove one way or the other. The petitioner made an argument based on a deduction that best suited them. The Supreme Court's response to the arguments on this legislative error was pointed and direct. It said, if use of or was a legislative error, why was it not corrected? The Revenue Department and the legislature certainly got to know of it when the issue came before the Orissa High Court and it was decided by it. Revenue Department really didn't have an answer to this question by the Supreme Court. To elaborate on the Supreme Court's response on the issue of legislative error, Supreme Court observed that the impugned judgment in the appeal was more than 5 years old. If the use of the expression plant or machinery was a legislative error as suggested by the Revenue Department, then the legislature could have stepped in to correct it. However, the legislature did not do so. Thus, the Supreme Court observed that it must be inferred that the legislature intentionally used the expression plant or machinery as distinguished from plant and machinery. And the Supreme Court added, if the legislature intended to give the expression plant or machinery the same meaning as plant and machinery as defined in the explanation, the legislature would not have specifically used the expression plant or machinery in Section 17(5)(d). The legislature has made this distinction consciously. Therefore, the expression plant and machinery and plant or machinery cannot be given the same meaning. And these are the exact words of the Supreme Court. Therefore, if the expression plant or machinery is given the same meaning as the expression plant and machinery as per the definition contained in the explanation to Section 17, we will be doing violence to the words used in the statute. While interpreting tax statutes, it's not a function of the court to supply the deficiencies. Thus, the Supreme Court chose both the path of non-violence and strict interpretation of tax statutes. Now, revisiting the three relevant parts of Section 17 again, Supreme Court held that the definition of plant and machinery as contained in the explanation did not apply to Clause D, as Clause D contained a different expression, plant or machinery. So now, Supreme Court was faced with the task of interpreting the meaning of this expression, plant or machinery, since it wasn't defined under the CGST Act. And this is where we come to Section 4. In trying to interpret and establish the meaning of the expression plant or machinery, the Supreme Court relied on and invoked the functionality test. Supreme Court said that the expression plant or machinery has a different connotation as compared to the expression plant and machinery. The former can include either a plant or a machinery. The Supreme Court here is basically saying that the two words plant machinery are not joined together, and it can be interpreted to mean plant individually or machinery individually. And as the word plant has not been defined under the CGST Act or the rules framed thereunder, its ordinary meaning in commercial terms will have to be attached to it. Supreme Court referred to a plethora of judicial precedents in trying to understand the meaning of the phrase plant or machinery. I will just refer to the ratio of these precedents and mention the facts in brief to keep the discussion more streamlined. The first precedent that the Supreme Court referred to was the Anand Theatres case. In this case, the issue before a division bench of the Supreme Court was whether a building which is used as a hotel or a cinema theatre can be considered as apparatus or a tool for running business, and thereby can it be termed as a plant. Supreme Court held that a building used for running of a hotel or carrying on cinema business cannot be held to be a plant. One reason was that the relevant definition of plant in this case did not include buildings. In the Anand Theatres case, the Supreme Court's observations were that every business requires a building, and sometimes a building is designed to suit the requirements of a particular business and industry. But merely designing a building to meet the requirements of a business does not make it a plant. The building has to be essential to business operations for it to be a plant. Clearly, Supreme Court distinguished between buildings that provide shelter or setting of a business and buildings that are used as a tool for a business. The second precedent that the Supreme Court in Safari Retreats case referred to was the Karnataka Power Corporation case. In this case, a three-judge bench of the Supreme Court held that the Anand Theatres case observation was limited to the buildings that are used for purposes of hotels or cinemas and will not apply otherwise. And whether a building is a plant or not is a question of fact. Supreme Court held that if it is so found that a building was so planned and constructed to serve an assessee's technical requirements, it will qualify as a plant. Though it needs to be said here that a building can be considered as a plant only if the relevant definition of the plant in the statute does not exclude building from the scope of a plant. Supreme Court in the Safari Retreats case cited both the above cases, examined their ratio, and said that after considering what was held in both the above cases, the position of law is as follows. The decision of Anand Theatre's case can only be applied if the building in question is a hotel or a cinema theatre, and the Karnataka Power Corporation case, a judgment of a larger bench, limited the applicability of the Anand Theatre's case. After clarifying the law as per the judicial precedents, the Supreme Court relied on these precedents to lay and restate with clarity the functionality test. The Supreme Court observed that if it is so found that a building has been planned and constructed so as to serve an SIC's technical requirements, it will qualify to be treated as a plant. But whether a building is a plant is a question of a fact. And the Supreme Court said, while the expression plant and machinery as defined by the explanation excluded land, building and other civil structures, however, the Supreme Court interpreted the term plant or machinery differently. And since the explanation was now held to be irrelevant for the phrase plant or machinery, the Supreme Court interpreted the phrase broadly and said that a building can also be treated as a plant. And finally, the Supreme Court also disagreed with one of Revenue's argument that the union cannot levy tax on land and buildings, and that in the impugned case the chain is broken and thus that's the reason ITC is blocked on immovable property. Now, very briefly, what did the Revenue mean that the chain is broken with regards to immovable property? The Revenue was trying to say that if the SIC pays GST on their inputs, which involve construction of an immovable property, and then later on if the SIC sells that immovable property, then the sale does not attract GST and that's the reason the chain is broken and ITC is blocked. The Supreme Court, however, said that the Revenue's claim is not entirely accurate and that GST is collected when an immovable property is sold before the issuance of a completion certificate. So it's not on all cases of sale of immovable property that the chain between the input and the output gets broken. Also, Supreme Court said that under Para 5B of Schedule 2 of the CGST Act, it is recognized that the activity of renting or leasing buildings is a supply of service. Even the activity of construction of a building which is intended for sale is a supply of service if the total consideration is accepted before the completion certificate is granted. Thus, the Supreme Court clarified that immovable property is not completely outside the purview of GST. The Supreme Court also clarified that ITC is available on a plant. And in Supreme Court's own words, therefore, if a building qualifies to be a plant, ITC can be availed against the supply of services in the form of renting or leasing the building or premises, provided the other terms and conditions of the CGST Act and rules framed thereunder are fulfilled. Therefore, the argument regarding breaking the chain cannot be accepted in entirety. The caveat that the Supreme Court added, though, was that if the construction of a building by a person is for their own use, then the chain will break and therefore ITC will not be available. And that follows from its interpretation of what it means to construct a building on one's own account. So, that brings us to the question, was the petitioner's shopping mall a plant? And this is what the Supreme Court had to say on this. The Supreme Court said that the High Court did not decide whether the petitioner's shopping mall in question satisfied the functionality test of a plant because the High Court read down the provision. However, each mall is different and in each case a fact inquiry is required and we will have to send the case back to the High Court to decide whether on facts the mall in question satisfies the functionality test. The Supreme Court clearly sidestepped the entire question. Now, this is the summary of Supreme Court's observations on the functionality test. The Anand Theatre's case ratio is only applicable in the context of hotels and cinema theatres. Functionality test is relevant to determining the meaning of plant or machinery. A building can constitute a plant, and whether a building is a plant or not is a factual question answered by determining if it serves the technical requirements of the SIC or the business. Now, whether this functionality test has any future under GST is not entirely certain. I will explain why. And for that, let me move to section 5 of this discussion. For those who follows India's tax policy closely, a retrospective amendment to the tax statute, if not inevitable, is not an entirely unexpected outcome when a decision is not in favor of the Revenue Department. And in this case also, we received a retrospective amendment, which, as I said, is not an entirely unexpected outcome. Immediately after the Supreme Court's decision, the Revenue Department's claim was that the Supreme Court did not understand legislative intent as encoded under the CGST Act, more specifically, as encoded under Section 17 of the CGST Act. The Supreme Court's alleged inability to understand legislative intent became one of the official reasons for amending the CGST Act. Sometimes, I think if courts start deciding tax cases on the basis of legislative intent and not on the basis of strict interpretation, the Revenue Department will then turn around and say that the court shouldn't try to understand legislative intent but only decide cases on the basis of what's written in the statute. Regardless, the Revenue Department's reason was a thinly veiled justification for trying to do what they wanted to do from the very beginning: deny petitioner's claim of ITC. And just so that we have a complete picture, the decision to amend the CGST Act retrospectively did not emerge only from the Revenue Department. The GST Council recommended a retrospective amendment to the CGST Act, and the Revenue Department followed through. This amendment is an opportunity for me to update or maybe contextualize the lemon lesson. We are told that when life gives you lemons, we should make a lemonade out of it. The Indian Revenue Department's version of this is, when a court pronounces an adverse judgment, use it as an opportunity to amend the law, preferably with retrospective effect. Now, what were the changes made to the CGST Act? There were two changes that were made to the CGST Act of 2017 via the Finance Act of 2025. First change. In Section 17(5)(d), for the words plant or machinery, the words plant and machinery shall be substituted, and they shall be deemed to have been substituted with effect from the first day of July 2017. So now both clauses C and D of Section 17 have the same phrase plant and machinery, and it is presumed that both these phrases have existed since the 1st July 2017 when this Act came into force. The second change that was made via the amendment was that another explanation was added to Section 17, which stated that, for the purposes of Section 17(5)(d), it is hereby clarified that notwithstanding anything to the contrary contained in any judgment, decree, or order of any court, tribunal, or other authority, any reference to plant or machinery shall be construed and shall always be deemed to have been construed as a reference to plant and machinery. So this explanation, in a way, not only nullifies the Supreme Court's judgment, but also pointedly limits the relevance of functionality test under GST. But for the Revenue Department, it seems the amendments or the retrospective amendments were not enough. The Revenue Department also filed a review petition against the Supreme Court's judgment. And the Supreme Court rejected this review petition by simply stating that they did not find any error apparent on the face of the record in its previous judgment. So, dear listeners or viewers, what did we learn from the developments relating to Safari Retreats case? Let me try and elaborate in this final section of the discussion. First question, is the functionality test still relevant after the amendment? The Supreme Court invoked the functionality test to elaborate on the meaning of plant or machinery. But the amendment has equated plant or machinery to plant and machinery, and the latter is defined in the explanation. So do we need the functionality test? Does it survive the amendment? Functionality test may be here to stay irrespective of the amendment. Its relevance might be limited, but I still think it survives the amendment. Now, why do I say that? Now, while the explanation to Section 17 may define the expression plant and machinery, there will be various factual situations that will require the interpretation of the explanation itself and its applicability to various and varied fact situations. And in doing so, it will be the functionality test which will come to the rescue, as it frequently does in situations involving the Income Tax Act. So, it is my opinion that the functionality test will continue to remain relevant, even if in a limited fashion, despite the amendment. Moving to the next issue, was there a legislative or drafting error in Section 17? Now, this is the CBIC chairman, Sanjay Kumar Agarwal, saying that the matter was looked into and it was found that the use of or instead of and was a pure drafting error. But he said this after the Supreme Court's decision. So I'm constrained to ask the same question that the Supreme Court did. Why wait for 5 years? If the CBIC knew or was used instead of and, why wait for all these years to find out if it was deliberate or an error? Why couldn't the matter be examined and the error corrected immediately after the Orissa High Court's judgment? We won't get an answer to that now, will we? So, even if the Revenue Department doesn't say so expressly, here is lesson number 2. It is tough to admit an error. Better to keep fighting till the very end and justify the error through interpretive gymnastics. Moving to the third question. We are all mortals, including the Indian Parliament and the Revenue Department, and we all make errors. But how do we rectify an error? And this is lesson number 3. An error should be rectified, but past sins should also be washed away. Hence, when rectifying an error via an amendment, make sure the amendment has retrospective effect. Leave no traces of an error. On to the next lesson. Through the Supreme Court's judgment, we get to know that tax laws are complex. Why? How? The answers are not easy to come by, and this aspect needs a little bit of explanation since I have not talked about this before in this discussion. Supreme Court in its judgment noted that the petitioner had also challenged the constitutional validity of Section 17(5)(c) and Section 17(5)(d). Supreme Court cited various precedents to underline that a discriminatory provision in a tax statute is not per se invalid. A cause for invalidity only arises when equals are treated unequally and unequals are treated as equals. Also, the Supreme Court said that the Parliament is entitled to make appropriate classifications since the constitutional jurisprudence gives it wide latitude in matters involving tax legislations. Now, this can be called the doctrine of deference in tax matters or the wide latitude doctrine. Supreme Court agreed with the Revenue Department that immovable property and immovable goods for the purpose of GST constitute a class by themselves, and thus clauses C and D of Section 17(5) are entirely distinct from other cases. And also that the right to claim ITC is a creation of the statute and the Parliament can always carve out exceptions to the entitlement of ITC. Finally, the Supreme Court said that blocking of ITC under Section 17(5)(c) and D seems to have been done to ensure that the object of not encroaching on state's part to levy tax on land and buildings under entry 49 of List 2. To add to the above, in Supreme Court's own words, moreover, to decide why transactions covered by clauses C and D are separately classified, the court will have to go into complex questions involving fiscal adjustments of diverse elements. The court has no experience or expertise to embark upon the said exercise. Ultimately, the legislature was dealing with a complex economic problem, and by no stretch of the imagination, clauses C and D of Section 17(5) can be said to be discriminatory. A policy-based rationale for blocking ITC under Section 17(5)(c) and D is still lacking despite all these above observations of the Supreme Court. All we get to know from Supreme Court is that immovable property is a separate category as compared to other properties or other movable properties under GST. And we also get to know that the union doesn't want to encroach on state's part to levy tax on land and buildings. But nothing beyond that. So, what is the lesson from Supreme Court's above observations? Here is lesson number 4. We should operate on the presumption that tax laws are complex, but we shouldn't even begin to ask what is the specific complexity that the provision seeks to address. Despite all the above observations of the Supreme Court and the Revenue Department's claim, we don't know specifically what is the complexity relating to immovable property that is being addressed by blocking ITC under Section 17.5C and Section 17.5D. We can only rely on deductions and guesses. Lastly, it is difficult, at least for me, to fathom as to why the Revenue Department filed a review petition. The Supreme Court decided against the Revenue Department. The Revenue Department decided to move an amendment and the Parliament approved. The amendment effectively removed the basis of the Supreme Court's decision. And you amended the Act retrospectively. After that, why did you go ahead and still file a review petition? I don't know. So, the final lesson from the Safari Retreats case and its developments is that don't give up hope. Be persistent. Be stubborn, maybe. I'm not sure of this one. What I am sure of is this, that I'm grateful to you for sticking around till the end. Thank you. See you in the next video.